We have Richard Greenman here. On the record in the matter of the people of the city of Lansing versus Richard Greenman, file number 20-01645, council appearance.
Assistant Public Defender John Lee appearing on behalf of Richard Greenman.
Okay, Mr. Richard Greenman, how are you?
Okay.
Okay, today was the date and time that we set this matter for sentencing. It looks like I saw you back in December, or at least the magistrate saw you in December. You then saw me on January 8th. I ordered you to undergo an assessment and provide it to the court. Where's the assessment? Why is that?
I completely forgot about it. A lot of stuff going on. My granddaughter was sick, she was in the hospital with RSV. And I had some issues with my job too. The main guy that I sub from.
You have custody of your granddaughter?
Her and my daughter live with me, so I take custody of her.
So her mother has custody of her?
Yeah, she.
Okay. Why didn't you get the assessment done as ordered?
I totally forgot about it. That was my fault.
Oh, we forgot about, just like you forgot that you were on probation previously? I'm sorry?
No, ma'am.
Okay. I don't know what your expectations are of the court. If we give you orders and you fail to follow them, what is it that what do you want us to do?
I was hoping I could go get that done as soon as possible.
Go get what done?
Assessment.
I have a sentencing update here. Let's see, no proof of treatment or 12-step was provided. Is that correct?
Yes.
Let's see. No testing, that's correct?
Yes, that was all for motivation. Yeah.
Let's see. No proof of employment was provided, that's correct?
Yes, sure.
Okay, so the probation officer met with you on the 30th after you appeared on the warrant. Let's see, 30th of December 2023, said the defendant stated that he knew he was running from his probation and knows he screwed up. The defendant reported working as a subcontractor, no proof on file. In addition, the defendant reported attending AA meetings at St. Mary's Church, no proof on file. The defendant is not currently enrolled in any testing, nor has he made any contact with his officer after our meeting, December 30th, 2023. The defendant did state during the meeting he would like to continue and complete his probation. And this is a matter that's been in warrant status for a very long time after you absconded after a guilty plea to impaired driving. And so you can make allocation.
Your Honor, Mr. Greenman has expressed remorse to me for this oversight on the assessment. He was ordered to do it, and there's really no excuse. Yes, he was dealing with some things, but his priority should have been the court, and that's what I told him. During this time of that he's been absconded, he has done some good things. He reports that he completed rehab last year, that he's able to get his driver license reinstated. Says that he's, has insurance, business insurance for his subcontracting business. But there really is no excuse for not getting the assessment done or not even trying to get the assessment done. He has expressed to me that he would like to do it, that he will make it a priority to do whatever he can do, even today, tomorrow, this week. And I hope that the court will understand.
I'm going to remand you to the custody of the Ingham County Jail because we don't have to go back and forth with you in order to get you to do what you're supposed to do. So if you can't remember on your own that you're on probation, if you can't remember on your own that you need to get an assessment, then we'll take control of the situation on your behalf. So you're remanded to the custody for 14 days Ingham County Jail until during that time there will be an assessment completed. So if that assessment can't be completed by our staff in 14 days, then you'll be there longer. Do you understand that? Once you have had an assessment, then you will return to me for the remaining term of your probation status, because I don't even know what treatments you may or may not need because you refuse to comply with getting me an accurate assessment. And the last assessment I had is over 2 years old. So you'll be remanded for 14 days or until the time the assessment can be completed. You're all set. You can give me the date, 30 days out. March 18th at 1:15. What do you have behind you?
This is Mr. Douglas.
Okay. On the record in the matter of the people of the city of Lansing versus Lamar Douglas. File number is 21-01320. Douglas, I do have a file here for you. What is this? Okay, I have requested summons for probation violation. It says that you failed to report on January 2024 to your probation officer. There's also a violation of 14 that you failed to do random testing on December 9th, 2023, December 28th, 2023, January 5th, 2023, January 8th, 2023, January 18th, 2023, January 21st, 2024. Actually, that should be January 5th, 8th, 18th, 2024, and 21st, 2024. There's also a violation that you failed to provide verification of 12-step attendance. You have the right to be represented by an attorney at this hearing. You have the right to have a contested hearing for the violations that are alleged. If you're found to be in violation, your probation status can be revoked and you can be sentenced to a term of jail time. Do you understand that?
Yes.
Okay, it looks like I have 2 updates from the probation. It looks like you allegedly failed to appear for testing on January 29th, and you failed to appear on February 5th for testing as well. Did you understand your rights as it relates to having a contested hearing?
Yes, ma'am.
Would you want to request an attorney to represent you?
Yes, ma'am.
Okay. I'll give you a date for a hearing. February 26th at 1:15, okay?
Okay.
Do you have any questions?
What day is that, man?
It's probably going to be on a Monday because it's a city case. Any other questions? Okay, you can meet with Mr. Lee if you've not already done so, okay? Mr. Lee, are you ready to proceed?
Yes, Your Honor.
Okay. On the record, in the matter of the people of the city of Lansing versus Maurice Jordan, file number 23L2821501. Council appearance.
Matt Staples for the city of Lansing.
Assistant Public Defender John Lee on behalf of Maurice Jordan.
Okay, Mr. Jordan, you can hear us, correct?
Yes, ma'am.
Okay, we reset this matter of the improper plate because proofs were still being verified. Were those able to be verified? Council?
Your Honor, we ran into some challenges. Mr. Jordan is trying to get the title to the car sorted out. He has a title after paying the owner for the car in a sale that occurred in Nevada. However, the title was not signed over to him properly, and the former owner is now deceased. So he is in the process of getting a death certificate from the state of Nevada that he will present to the Secretary of State as a means to get title free and clear in his name so that he can get the car registered.
Okay, so you need additional time?
Yes, please.
Give me 30 days.
March 8th at 11.
March 18th at 11. Do you have any questions for the court today?
No, ma'am. Thank you very much.
Okay. You're welcome. We'll see you March 11th. You're all set.
Thank you. Thank you.
Okay, on the record in the matter of the people of the city of Lansing versus Dominic Salazar. This is file number 23-00201. Mr. Salazar, today is the date and the time that's set for an arraignment on a probation violation. I have a request in summons for a probation violation alleging that you failed to do random testing on November 6th, November 19th, December 3rd, December 17th.
Yes, Your Honor.
I'm not finished yet because it looks like they put some additional things in the file that they have yet to issue a summons on. It says you failed to show for testing January 18th, January 21st, January 5th, January 8th, February 6th, and January 29th. So you have the right to have a contested hearing. You have the right to be represented by an attorney at that hearing. If you are found to be in violation of your probation status, your probation can be revoked and you can be sentenced to a term of jail time. Do you understand that?
Yes, Your Honor.
You could also end up with additional sanctions or oversight as a penalty for any violations to your probation status. Did you want to request an attorney to represent you?
Yes, Your Honor.
Okay. We'll set it for a hearing. It's in person at the court.
February 26th,
February 26th, at what time?
1:15.
At 1:15 in person at the court.
I'm sorry, it broke up. I'm sorry, what was that?
Your hearing is gonna be February 26th at 1:15 in person at the court, okay?
Yes, ma'am. I'm sorry. I just want to apologize to the court and everybody in the court. I would have been there personally today, but I tested positive for COVID Friday morning, and otherwise I would have been there this morning or been there this
Yeah,
afternoon.
you don't need to apologize. Your arraignment was via Zoom, so you don't need to appear in person for that, okay?
Okay, I just want, like I said, I just wanted to say sorry because I thought I had to be there in person today, but I wasn't because of my COVID. But my probation officer said it was okay to appear on Zoom. So I'm sorry. I know I don't have to apologize, but I am apologizing.
Oh.
So let me write that down right now. You said the 26th at what time?
1:15.
1:15. Okay, thank you, Your Honor.
No problem. Do you have any questions for the court?
No, I do not. I will be contacted by a court official before then.
No, you're gonna meet with Mr. Lee right now. I'm putting you in a private meeting room.
Okay, thank you very much.
You're welcome.
Things up there, judges up there, for courtroom. Yeah. Oh, shoot.
Okay, I see a Gregory Young.
Yes.
Can you please start your video? Okay, Mr. Young, I think you're a little bit early, but we're waiting for the attorney to be here on Discover Bank so that you can complete a pre-trial, okay?
Okay.
Once they do arrive, I'll put you in a private meeting room with them, okay?
Okay.
Mr. Brunette, you're here on behalf of LAFCU in the matter versus Charles Wisely.
That is correct, Your Honor.
Okay, no one's appeared on behalf of Charles Wisely, and you can do a show cause if you like.
Okay, thank you, Your Honor. That's what I was thinking too. I didn't want to take up the court's time by asking for an adjournment or anything. So I think if we just reserve the right for a show cause, that would be great, Your Honor.
Okay, thank you.
Okay, thank you, Your Honor.
You're welcome. Okay, someone is here from Velo Law.
Yes, Your Honor. Lee Melby?
Okay, which matter are you here for?
I'm here for Sparrow Hospital versus Hilario Martinez.
Okay, sounds good. Thank you.
Thank you.
I can stop my video.
that you're back?
Yes, I apologize, Your Honor. We received a notice to appear for Laftew versus Ned Sanders. I just want to make sure that I wasn't missing anything there and that it wasn't also on your docket.
I don't have a Lafferty versus Ned Sanders today.
He showed up here too, that case is closed.
Our file shows that that case is closed.
Okay. I understand. We were unable to serve him with the original subpoena, but we did receive a notice to appear. So I just wanted to make sure we're on the same page. So I
Correct.
suppose that's all I have for you.
All right, thank you.
Yeah, thank you,
Thank
Judge.
you. Millicent Scheck.
Hello.
Hi, how are you?
Good. How are you today?
Pretty good. Are you signing in for the 2 o'clock matter?
It's a 2:30 matter, Your Honor.
Okay, well, there was a 2 o'clock Delhi Township versus Shannon. Is that the one I just signed? Okay.
Your Honor, my court notice, and I can show you through the camera, has 2:30 on it.
That same matter, the Delhi Township matter?
Yes.
Okay, it says 2 o'clock on our docket. What does it say in the file? Because I signed an order. I think you submitted a proposed order on base, I believe.
Yes, Your Honor. It was just to set aside the dismissal. I had learned that this was dismissed when I was rotating my files. And when I called the court, they stated that a notice went out and nobody appeared. My office never got a copy of that notice, Your Honor. So as soon as I learned that, I filed a motion to set aside the dismissal.
Okay, I see the notice of hearing. I don't know, did you put that time in here? Because it doesn't look like a court.
I did not, Your Honor. I submitted a blank notice of hearing.
Yeah, we nonetheless, when I saw that they didn't appear at 2 o'clock, I signed the proposed order that you gave, so.
Okay, great. So this should just be set for another pretrial then, correct, Your Honor?
That's correct.
Thank you. Appreciate the court's time today.
No problem. Mr. Pryor. 2:30, okay. You have a device to get on Zoom.
I have a device. Last time it was a problem.
Yeah, it looks like. Yeah, let's see feedback. No, something's ringing. Okay, let's see here. 133. Hearing docket, 133. why did you believe, you said it was an issue when you logged into Zoom last time. We handled your matter via Zoom last time. What do you mean?
No. When the last time that I had court with you, like, not the last time, but the time before that, I had problems with Zoom, so I didn't do that. Then the last time I came in here, I handled it. I was in person, you had the other party on Zoom.
Correct. Well, the reason why I'm actually gonna Zoom now, because the other party's here on Zoom.
Yeah.
And today is a pre-trial, so you have to meet with them privately.
Okay, I just don't, it doesn't work properly for me.
We can get you on our device. Okay, Mr. Zaney, you're here on the prior matter?
I am, Your Honor. Good afternoon.
Okay. Good afternoon. Mr. Pryor is here in the courtroom. We'll get him on the court's device to see if you all can either come to resolution or do joint pretrial statement.
Yes, ma'am.
Okay. Signed grant. Someone's in the waiting room. Let me see. Two. Let's see. I see a Jennifer Palon.
Yes,
Okay, you're here on the matter of LVNV funding versus Otelia Watson.
yes, I am. Thank you, Your Honor.
Okay, I've not yet seen anybody present on behalf of Otelia Watson, but we'll give it a couple more minutes. And then I see that I have not yet seen anyone here for Hilario Martinez either, so we'll give that a couple more minutes as well.
Thank you.
No problem. Is anybody here on behalf of Discover Bank?
Yes, Your Honor, Daniel Best here, P58501.
Okay, thank you. Mr. Best, we do have Mr. Young here. Can I put you on a private meeting room so you can either work out resolution or come to joint pretrial statement?
Please, Your Honor.
Okay, I'm gonna put you in room 3. Hi, what's your name?
I'm Attorney Richard Gruson. I'm the plaintiff for record for LBNB funding versus Watson.
Okay, Ms. Palon, who were you representing?
Miss
Watson, correct?
Watson. Yes, thank you.
Okay.
Yes.
Okay, I'm gonna put you and then Mr. Rusin in a private meeting room to come to either joint pretrial statement or you can work out resolution if possible, okay?
Yeah.
Okay, no one has appeared on behalf of Hilario Martinez. Would you like a default to be entered?
Yes, please, Your Honor.
Okay, you can file one through my file.
Okay. Thank you.
Thank you. Um, Let's see, Mr. Rusin and Ms. Palon, did you all come to a resolution or a joint pretrial statement?
Well, no, well, we came to a resolution for the pretrial statement, Judge. I don't have a settlement to put on the record with you at the moment, although I can tell you as an officer of the court that my office has been in regular contact with Ms. Pellion's office, but we don't have the authority yet as attorneys to put a settlement on the record. So I suggested to Jennifer that when we came back in your court that we would ask for a standard pretrial order made for 60-day discovery, all the usual things that you put in your pretrial scheduling order. In the meantime, both Jennifer and I agree that we're probably going to work on get this settled, but that's where we're at the moment.
Okay, we don't do standard pretrial orders here. We work through it, each is case by case. So that's why you were supposed to do a joint pretrial statement, and especially if we have two attorneys on there, we expect you to work out your pretrial statement. But because you all are highly likely to come to resolution, what may be easier is for me to set this out for another pretrial date, giving you time to work on potential resolution. How much time do you think you might need?
I'll leave that to Jennifer. What do you say, Jennifer?
I think that if we did a 60-day, I think we hopefully wouldn't need to use any further court resources.
Okay, so we'll reset this. We'll give you a date in just a moment.
All right.
Okay, thank you.
No problem. April 15th. Tax day. April 15th. At what time?
Well, that sounds good. And what time would that be?
2:30.
Sounds wonderful.
Okay, you're all set for today.
All right.
Thank you, everyone. Have a great day.
All right. Bye.
Same to you. On the record in the matter of Anthony James Pryor versus Simon Zaney, file number 23-02133, counsel appearance.
Good afternoon, Edward Zan, on behalf of Simon Zaney, Your Honor.
Were you all able to come to a joint pretrial statement or a resolution?
No, Your Honor, we attempted to fill out the pretrial statement when Mr. Pryor began to swear and then disconnected. So
Somebody have a copy of our pre-show?
I have one pulled up, Your Honor, that I attempted to work through, 54A District Court pretrial statement. If you'd like me to work off that, and then I can email it over.
Uh,
Can I say one?
yes.
Okay. I would have never had used one word, which was a swear word, because I was very upset. But he asked me what kind of evidence I'd be entering in, and I asked him if the police report was considered part of documents or if it was a separate police report, if it needed to be marked separately. And he says, "Do you mean the police report where you assaulted my brother?" No, he entered my vehicle.
Okay.
But I'm just like, that pissed me off. No, don't start playing games and
Okay.
lying.
Well,
If we're trying to-
hey. You
I was
can,
trying to
that
say-
might work in the private meeting room there,
No, that's
but all that energy don't work well in
No,
here, okay?
no,
So
ma'am,
your
I
voice
know.
was elevating. We don't need that. I understand that, first of all, you're asking someone who's representing him to clarify something for you.
No, I'm not
That-
asking you.
Yeah, you did. You asked him if the police report was considered documents, and that's how that interaction started. And so you're not gonna get him to give you any legal advice as to what to be considered as the production of documents or evidence that you're gonna produce, okay?
He was
That's-
asking me that question.
He asked you, he
What was
probably,
I gonna be giving to you? And
as
that's-
evidence.
Yes, and that's part of it. The police report, videos,
But
pictures. We went over all.
your response, at least what you said to me just now, was that you asked him if
I
the
said-
police
I said the
report,
police report,
do
we
you
just-
want me to say what I gotta say, or you wanna talk over me?
Sorry.
What you just said to me was that you asked him if the police report would be considered evidence. You're asking his attorney what would be considered, that's what you just said to me on the record. What did he say? I have, it's recorded. Your specific statement was,
Would
you asked, no, this is what you said to me. I don't know what you meant to say. Was that he asked you what evidence you're gonna present? You said, is the police report considered a document for evidence? And he said, you mean the police report where you assaulted my brother? That's what you said.
This is how it happened. Can I say it one time?
Okay.
Clearly? He was going through a list and just checking them off on his own on his side. And he said, okay, documents, pictures. I said, well, what about the police report? Wouldn't that be considered documents? That's all I said. And that's where he went into the childish thing about me assaulting his brother, but his brother entered my vehicle.
Okay, that's your
Right.
position and that's his position. I don't expect them to
Right.
meet
I didn't
in the
need
private
police
meeting room.
report for
Okay?
no reason.
Okay, I don't expect those positions to meet. That's why we're here in the court. If you guys saw this the same
So
way,
it
we
should
wouldn't be
never
here.
happen that I can't do that with him.
Okay, well,
Because it's a long-
what
I've
shouldn't
known
happen,
him for
what shouldn't
30
happen is you shouldn't talk over me.
Yes,
So
ma'am.
whenever I talk, you close your mouth. You can't talk over me, okay?
I understand.
So there's an attorney on that side. Even if there wasn't, the expectation was that there's a standard form that should be completed. I'm happy to do it for you, but it really is not a good use of the court's time if there's an attorney who knows what these things are, who can go over that and complete the court document that's necessary for the form. But because you all can't come to an agreement together, then I can go over it for you. Did you complete your side, Mr. Zaney?
I was in the process of it. Yes, I can go through
You
it
can have-
quickly. I'm prepared to answer it.
Okay, can someone give me a copy of our form, please? It should be a pre-trial form. Okay, the issues, this is a breach of contract, or what was the issue?
It seems as such, Your Honor.
Is that what you're suing for, a breach of contract?
And lack of craftsmanship, improper installation of a roof, however it's categorized.
Okay, so that would be the breach of contract. You contracted with him to do a certain service and you're not satisfied?
Nowhere near.
Okay, the pleadings, that would be the court documents that's been filed so far, and there's a summons and complaint. I believe there was an answer filed. There was one motion, I believe, that the court granted. And so I would state that pleadings are in order. Are you in agreement with that, Mr. Zaney?
Actually, Your Honor, defendant, today we filed two separate motions to correct the pleadings. Defendant's first motion to amend pleadings, as well as a motion for a more definitive statement under MCR 2.115. Those were filed electronically using the M-File system. Motion fees were paid on both of those motions. We do anticipate a future motion for summary.
Okay, let me reread this Simmons complaint. This is I, Anthony Pryor, come before this court in the matter where I hired a contractor to replace my roof on a home I purchased by land contract. We initially agreed to a price, okay, at the beginning, I believe that's an @ sign, of 2022. In May, I started to pay the contractor for the labor and purchase all needed materials for the project from Menards and ABC Supply. In total, the contractor said if I pay $6,500 labor and buy all the materials, he would complete the job. He said it would commence in June 2022, a few weeks later after my initial payment to him, which was May 31st, 2022 of $1,000. Well, in June and July, I was given excuses in August. The contractor told me he was 2 weeks out, so to send the money over.
Owed.
Oh,
The
send the
balance
money
owed,
owed. I sparingly sent 2,500. What does that mean, sparingly sent?
Well, because I would have had owed him 5,500, because I only initially gave him 1,000, so I would have left 5,500. So, but he wanted me to send him the whole 5,500 because they were about to show up, but he's already
Okay.
given me a few.
Okay, I sparingly sent 2,500. I'm just trying to understand why you
Yes,
used the word
ma'am.
sparingly. That was
Yeah,
my concern. On August 11, 2022, and again was told it would be before August 30th, 2022. September and October came and went, and I started to question the contractor about time for winter. So November 10th, he said he would be on site the next day. So I sent 1,000 more, November 10th, 2022, and November 11th, 2022, crew showed up. November 11th. Hold up here. 2022, they began the job, tear off the home and garage, the exterior roof,
The entire roof.
the entire roof, what?
Sheeting and all.
Sheeting and all. Our contract was for tear off and replacement of entire roof and disposal of materials and cleanup of size after job complete. On the first day of tear off, 2 of the laborers sent to my home were stealing brand new, what does this say?
Bundles of shingles.
Bundles of shingles and burying, is that what that
Yep,
says?
and burying them in this truck.
In his personal pickup. I'm just gonna tell you right now, if I gotta have you here for me to read it, then they can't read it. Okay, so then that means you're gonna have to, at bare minimum, type this so that they can read because your handwriting is not always easy to read, as you can
I
see.
understand.
Okay, let's see, shingles and burying them in his personal pickup truck with debris from my roof, so I wouldn't notice them stealing supplies. Is that what that says?
Shingles.
Oh, shingles off my pile of brand new shingles, 6 bundles. So after 3 days of agony babysitting the thieves sent to my home, the roof was what the contractor called complete, said he just had to finish cleaning up and asked me to pay him the balance of $1,000 for labors. I informed I would when the job was complete. He assured me the next day. This was Thanksgiving Day, 2022. Well, 2 weeks later, nothing. And what is, okay, and in the interim, I noticed a mountain of debris in my attic. He agreed it would be cleared, give him a couple days. Okay, I have not yet seen your motion. But I do think that to some extent, this does need to be clarified. I don't know if it was you were handwriting and you were trying to hurry up and do it. The court rules require that when you file a motion, I'm sorry, a summons and complaint, that you formulate it or you articulate it in a way that the person you're suing has a clear understanding of what you're suing them for. And so it sounds like the defendant has filed a motion for a more definite complaint. Is that what you're asking for, Mr. Zaney?
Yes, ma'am.
So I haven't read it yet. My understanding, just based off what I've tried to read here, although I can get the gist of what you might be saying, is that it would be helpful and beneficial that you clarify your pleading. I'm going to require that you type it because this handwriting is a little difficult to process. And then to the extent that they're requiring you to comport with the court rules, I mean, I guess you could if you were an attorney or you were legally trained. I probably would not be able to get you to properly file a complaint that completely comports with the court rules, but I think you can make this a little bit clearer if you rewrite this, and I want it typed. And that way they can understand better what you're alleging occurred. And so based on this, I think you're also alleging some theft, but I'll wait for you to refine your answer or your complaint, that is. I'm going to go ahead, since you have filed that motion, Mr. Zaney, I'm going to hold off on the pretrial statement because that might clarify what some of the issues are. And then that may also explain what further motions may be needed and then what exhibits we can go through. But right now, if we're still working through the filing of your complaint because they want it to be clarified, I'll give more time for you to do that. I'm going to give you 14 days to do that, okay? So I'm going to give you a new date. You're going to have 14 days to file a more definite summons and complaint. And then that'll give Mr. Zaney an opportunity to respond to that complaint and then make any counterclaim if that's what they want to do. And then we'll have a pretrial after that is done. So you have 14 days to file that. Once you file that, you also need to serve a copy of that on the defendant, okay? And you'll do that to the defendant's attorney, okay?
Yes,
Do you
ma'am.
need their information on how to contact to serve it or
Not at
copy?
all. I know.
Okay, and Mr. Zaney, would you like an electronic copy filing or do you want him to file it by mail?
I would prefer an electronic copy, Your Honor.
You can email him a copy?
Simply take a picture of my phone and email it, that type of email?
No, if you're gonna type this, was what I'm saying, the best way to serve
forward
him
it.
is to forward it to him via email. That's what we're saying,
Just need the
okay?
address, yeah.
Correct. I don't think in this case it's in either of your interests for you to appear to his office personally.
Oh, no, I would
to try-
mail it. I wouldn't never go to his office.
Correct,
anyway.
but you know what, but now we do a lot of things electronic, so
Yeah,
you
that's
need
fine.
his email address?
Yes, please.
Okay, what email address, Mr. Zaney?
Thank you, Your Honor. Edwar, EDWAR at Z as in zebra, I as in India, NEHLAW.com.
Can you give that to him, please? Okay, and so, Mr. Zaney, you'll have 14 days from the receipt of his new complaint to file your response with the court, okay?
Yes, ma'am.
Can I have a new pretrial date 30 days out? March 18th at 2:30. Does March 18th at 2:30 work for you?
For me, Your Honor?
Correct.
Yes, ma'am, it would. It is via Zoom again?
That's fine.
Thank you, Your Honor.
Okay, March 18th at 2:30 will be the new pretrial date, and by then I'll have the new complaint, and I'll have Mr. Zaney, your response, and then we'll know how to proceed by then, okay?
Yes, ma'am.
Do you have any questions today, sir?
How do I bring it here to the court to just refile it basically
Yep, you'll go right to the clerk's office on the 5th floor.
and just add it to the file?
Yep, the top of it, you should put amended complaint. Okay.
But just, that's right.
And tell them, yep, you'll take it to the 5th floor, which is down one floor,
Sorry.
and you'll tell them you're here to file an amended complaint. They'll see my notes in the system that say that you need to file that, so they'll know what you're.
Okay.
Okay, do you have any other questions?
Not at this time.
Okay, any additional matters for the record, counsel?
No, Your Honor, thank you for your time.
No problem, thank you, sir.
Thank you.
Did you need a notice to appear?
Can I get one? please?
Yes.
Just so I have it.
Take a seat. I'll grab it.
All right, thank you. And I apologize earlier, but very touchy situation.
Yeah, that's why the court's here. Thank you. Mr. Best?
Yes, Your Honor.
Okay, were you all set? I think you were meeting with Mr. Young, correct?
I was, Your Honor. We've engaged in some quality negotiations, although we still have some way to go. He is working with a debt settlement company, but they did provide him a couple offers to relay. I've given him a counter offer. And so we did discuss dates. And I think you had asked the court just to open discovery for 60 days, set a motion cutoff for 90 days, and set this for trial sometime after 120 days.
Okay, so you're gonna file the joint pretrial statement?
Yes. Where do I find that? Does the court have a form that you want us to use?
Correct, we do have a form that should be used, and you can file that on my file. But did someone provide him with a copy of the form? What's your email? We'll provide you a copy of our court form for joint pretrial statements.
Very good. DBest, my first initial last name, DBES, at Weltman, WELTMAN.com. And Weltman is the first name of the firm.
It broke up a little bit. Can you give the email again? DBest at what?
Weltman, WELTMAN.com. And Weltman is the first name in the firm.
Okay, thank you. Get that sent over to you, and then you can execute and sign and date it. So you would rather do that versus having another pretrial date? Because if you think you're gonna come to resolution, I could just give you another pretrial date.
I'd say let's get the process flowing. So I'll go ahead and get the joint pretrial statement.
Okay, sounds good. Mr. Young, do you have any questions today for the court?
No, Your Honor, I do not.
Okay, very good. Any additional matters for today, or are you all set, Mr. Best?
I just would like the defendant to confirm that the time periods that I placed on the record here are acceptable to him for the pretrial conference form.
Yes, I agree.
Thank you.
Thank you. You're both all set for today.
Thank you.
Thank you.